Hello, everyone, and welcome to our webinar. We're going to wait just a moment as more people join us, and then we'll get started. Hello and welcome, everyone. We'll go ahead and get started, and others can join us to jump in. My name is Stephanie Baez, and I am pro bono counsel with the ABA Commission on Immigration. And I'm thrilled to welcome you today to our presentation on Citizens of Nowhere representing a stateless client. Today's webinar is hosted by the ABA Commission on Immigration with our panelists, Karina Ambartsmian-Clow, Samantha Sitterly, and David Benian. One housekeeping note before we begin. This is a non-CLE webinar. The PowerPoint that you're going to view during today's presentation will be distributed to all attendees after the presentation. And if you have any questions today, please put them in the Q&A box, and our panelists will answer them at the end of the presentation. I'll remind everyone of that. If they're in the chat, we'll move everything over to the Q&A box so it's easier to answer at the end of the presentation. Now I'm going to go ahead and introduce our panelists, and we'll go ahead and get started. Joining us today, we have Samantha Sitterly from United Stateless. Samantha is United Stateless's first staff attorney, and she resides in Boulder, Colorado. We're also joined today by Karina Ambartsmian-Clow. I'm sorry, Karina, for butchering your last name. And Karina is the founding member and executive director of United Stateless. Karina is located in Philadelphia, Pennsylvania. And also on our panel, we're joined by David Benian, who's the executive director of Free Migration Project and a practicing attorney based in Philadelphia, Pennsylvania. We're so grateful for our expert panelists for joining us today. And so now, without further ado, I'm going to turn it over to them. Thanks all.
Thank you so much, Stephanie, and thank you everyone for joining us today. We're so excited to be here. We do have a lot to get through, so I'm just going to jump right into it. We hope that you're here today to learn more about this very important issue that, in fact, few people, including seasoned immigration attorneys, know very much about. So we're going to be covering a little bit about this topic, but I will point out that we did have a previous CLE through the ABA called Understanding Statelessness that you can also view in their library, and it gives a much more detailed background of the issue and its causes. What we're going to be getting more into today are the specific legal obstacles, guidance about representing stateless immigrants in immigration court and before other immigration authorities, especially talking about asylum, talking about some orders of supervision, and then we'll get into some case studies. And so I hope that you learned something. And with that, I will pass it over to Karina.
Hi, everybody. It's a pleasure to be here. Thank you so much for taking the time to join this call. The next couple of slides, I'm going to give a little bit of an overview of the issue of statelessness. Like Samantha mentioned, it goes into detail in the previous training with ABA, but stateless person is one who is not considered as a national by any state under the operation of its law. Please make note of the underlined words here, not considered, and under the operation of its law. This means that stateless people are not recognized as citizens by any state or country. We are often referred to as citizens of nowhere, and we are then not entitled to any rights and benefits that come with citizenship, like travel, education, access to healthcare, employment, etc. The occurrences of statelessness is rooted in discrimination and is often the prelude of atrocity crimes. Yesterday, the world commemorated Yom HaShoah, or Holocaust Remembrance Day. Next week, April 24th, is the 108th commemoration of the Armenian Genocide. Both of these atrocities occurred during world wars and began with denationalization or stripping nationality rights from a particular group of people. It started with statelessness. There are 218,000 stateless people in the US, and I am one of them. Next slide, please. The phrase, the right to have rights, was coined by political philosopher and stateless person, Hannah Arendt, who argues that citizenship is the foundation of all human rights. Citizenship is not just a legal status or a set of rights. It is duties and is fundamental condition for human existence and dignity. Lack of or barriers to citizenship is torture. The concept is also related to Chief Justice Earle's opinion in Trope with Duelis, The case raised questions whether citizenship is an inherent right and that cannot be taken away, or a privilege that can be forfeited. And in his opinion, Chief Earl Warren supports the concept and emphasizes that governments must power to regulate citizenship must be balanced with the need to protect individuals and to uphold the principles of democracy. Next slide, please. These are the international frameworks that support statelessness and coin the definition, along with how states are supposed to address the issue. Notice the dates of some of these frameworks. They were released post-World War II, during a time when the world saw a mass displacement of people. The winners, the victors, luckily got together and organized United Nations High Commission for Refugees and began to try to come with reason of how can states really understand that there are people in their countries that are refugees and also stateless, and what are the appropriate steps countries need to take to protect rights and privileges. It's really important to note that the US is not a signatory to any of the conventions, but some of the legal framework of statelessness is not formal, but rather is based on international customary laws. These international instruments recognize the seriousness and consequences of statelessness in the lives of individuals, and they aim to provide legal protection and assistance to stateless people. The conventions promote the prevention and reduction of statelessness by setting guidelines for states. And outside of this, there are plenty of resource materials that we'll be sharing later on for you to understand what the solutions are there. They're pretty simple. States need to pass laws to address statelessness within, adopt the international definition that I mentioned earlier. But the hard part is the political will. Next slide, please. There are themes of how stateless people become denationalized or without protections. And in the United States, stateless people are often foreign born because the 14th Amendment to the Constitution guarantees citizenship at birth. And in practice, that is granted at the child's birth. So most of us are foreign born. In some cases, stateless people become stateless as a result of displacement, while in other cases, displacement may result to statelessness. Next slide, please. And we will dive deeper later in this space, but there are people in this world that were never given a birth certificate. There are people in this world that are born in countries that don't exist anymore, or have been stripped of their citizenship. With over 195 different countries, with its own laws of nationality laws of those born in their country, and also nationality laws of nationals living abroad. It can get really tricky to prove that how someone is stateless, especially in a country where there is no legal framework. But fortunately, there are almost like evidences that a person can gather. One is lack of documentation, any communication with national authorities, including embassies and consular offices. And we'll again go deeper into the UNHCR Stateless Advisor opinion and some of the affidavits and testimonies. Next, please. And over to Samantha.
Yeah, so I'm going to talk a little bit now about the specifics of when you do have a stateless client, some things to keep in mind, and starting with being stateless in immigration court. This begins with the NTA, with the notice to appear. At the pleading stage, you should be raising the issue of statelessness for your client, and it's your first opportunity to educate both the immigration judge and the Department of Homeland Security, first of all, of your client's status, but also of this issue, which again, even immigration judges, Department of Homeland Security are largely unaware of the issue and its particular legal challenges. So how do you designate a country of removal for someone who does not have a country? This is discussed in INA 241B. And I will also point out that this is slightly different for arriving aliens versus non-citizens already in the United States. So I would just direct you to that statute and also the Supreme Court case JAMA versus ICE to make sure that you have the correct analysis of how best to designate the country of removal. But this is basically a four-step analysis. Number one, the non-citizen gets to choose, but DHS can disregard the non-citizen's choice if the person is not a citizen of this contiguous country, Canada, Mexico, and also surrounding islands. If DHS makes an inquiry to that country and there's no response within 30 days, or the government is not willing to accept that non-citizen or be otherwise prejudicial to the US. So step two, the country of citizenship, similarly can be disregarded by DHS if there's no response, if the country's not willing to take that person. And then step three, where there's a lesser connection, particularly the country where the person was born, or the country where the non-citizen last embarked from. And if that doesn't work, any country that will take the non-citizen. This can be a tricky analysis for someone who goes through all four steps and there's still no country. My suggestion is it's going to be probably a fight, and it may lead to a contested hearing on this issue specifically. And also pointing out that you can object to the designated country if the person will be facing persecution in that country. But we'll get into that also a little bit later, how to address that. So there's a lot of overlap with refugee law and statelessness. And a big reason for that is that statelessness is a human rights violation. We at United Stateless take the position that all cases of statelessness are persecution or even torture, but the case law is a little bit more varied. But we strongly believe that it is a violation of international laws and treaties which guarantee the human right to a nationality. It is a deliberate policy choice on the part of governments. Looking back to that framework, those international framework, there are pathways to address statelessness within every country. There are ways to reduce, prevent, and eliminate statelessness, and governments simply do not have the political will or ability to pass those laws. This is a policy choice. And finally, the fact that statelessness, existing as a stateless person, is excruciating on the individual. Think back to that quote from Chief Justice Warren. It's an abhorrent status to live in. You are denied the right to have rights. So therefore, we strongly believe that it's persecution per se. However, case law is not quite as strong. Here's a couple citations of some cases that say that statelessness alone is insufficient, and there has to be a persecutory reason for the person having no citizenship in order to form a basis for asylum. And also to keep in mind, the impossibility of removal due to a lack of travel document or citizenship is actually irrelevant to the asylum eligibility, right? The question is whether they fear returning to their country of last habitual residence. And we'll get into that a little bit more as well. I also suggest that immigration practitioners should consider statelessness as a basis for asylum when you do have a stateless client. So we already discussed, right, statelessness as persecution. It'd be the loss of the right to have rights, and it really is more than simply discrimination or harassment. It truly affects the ability to have any protections whatsoever. You can be removed, you can be abused, you can be denied the basic necessities of life, including education, employment, healthcare, denied identity, personhood, in many cases, birth certificates, marriage certificates, death certificates, and it goes simply beyond a difficult existence. Statelessness may also be considered as a grounds for protection itself. Consider national origin, right? Consider political opinion, the opinion that you believe that you have a right to citizenship of the country where you were born or where your parents are from. And of course, a particular social group. There's also race or ethnicity, and religion often form the basis for the discriminatory laws that deny an individual citizenship. And also there's something like 24, 26 countries in the world that discriminate against women in their nationality laws, meaning that women do not pass their citizenship on to their children in the same way that men do. Just keep in mind to avoid that circular definition problem for a particular social group. Grounds for protection, you don't want to be saying that it's a stateless person is the protected ground, and then also the only persecution is being stateless. So just keep in mind, and you may want to go, but it depends, right? It will depend on the case and the facts as to whether the statelessness is the grounds for persecution, or whether the statelessness is the persecution itself, or both. But just keep in mind avoiding that circular definition trap in asylum claims. So I hope that makes sense, and I'm happy to talk more through that if someone has particular questions about that. Also, I wanted to point out that withholding of removal can be a really important protection for somebody in asylum proceedings, because withholding of removal is actually withholding against from the country where the person has been designated removed. And that can be different from the country that the person is claiming fear from. I'll get into the next slide. Is we're going to discuss nationality determinations, but withholding of removal may be available where asylum isn't, if the country of designation of removal is different from the country that has determined to be the nationality or last habitual residence. And also consider CAT protections, Convention Against Torture protections, because statelessness has been determined a violation of the 8th Amendment under the US Constitution. You can analogize that to other forms of statelessness. That's denationalization, actually, that Trop versus Dulles. That was that quote earlier in the program, that it's a form of torture to be denationalized. I think you can analogize that to other forms of statelessness, meaning, denial of citizenship from birth or otherwise loss of citizenship is a form of torture. And so consider that if your asylum claim may not be successful. So the nationality determination in asylum claims is different from the designation of the country of removal. But this is also part of that NTA, right? And so this should be talked about at the time of pleadings. So consider this refugee definition is any person who is outside of any country of such person's nationality, or the statute actually does contemplate statelessness, in case of a person having no nationality, is outside any country in which such person last habitually resided and is unwilling or unable to avail him or herself of the protection of that country. And so the country of last habitual residence is obviously going to be the operative question for an individual who is stateless or a citizen of no country. It's not explicitly defined in the INA. However, it does define residence. The INA does define residence, which means the place of general abode. The place of general abode of a person means his principal, actual dwelling place, in fact, without regard to intent. This has been analyzed by courts several different ways. The Third Circuit, notably, is a quantitative approach, meaning how much time you have lived in a particular country. Other circuits is more of a qualitative approach. Even though it says without regard to intent, it does take sort of a totality of circumstances analysis there. It's super, super important when you are submitting pleadings to consider this. What is the appropriate nationality under the refugee definition? Obviously, a person who has no country cannot avail him or herself of the protection of that country. So that language also is really important in these asylum claims, that you can really assert that, of course, a person with no citizenship will not be able to access the protection of the country of their nationality or last habitual residence. Firm resettlement concerns come up quite a bit with stateless individuals. So firm resettlement is a bar to asylum. It means that the person has left their country of last habitual residence or nationality, moved to a third country, and is eligible for permanent residence. This is after the alleged persecution has happened, and there's no persecution in this third country, or sometimes called a safe third country. It is irrelevant if the person actually applied for or received permanent residence in this safe third country, as long as it's established that the person was eligible for it. So this can be really tricky for individuals passing through certain places or perhaps in refugee camps. It's also important to note that the person must be physically present in that third country and voluntarily. In 2020, these rules, the federal regulation was changed to be a lot harsher on these firm resettlement considerations. So that includes if the person is longer than 1 year in that third country, there is a presumption of resettlement. Migrant protection protocols, remain in Mexico, whatever we're calling it nowadays, is accepted explicitly in that it's the statute and regulation. And so, but it is a rebuttable presumption of firm resettlement. The rule used to include some explicit considerations that an immigration judge should take into consideration whether the firm resettlement has occurred. Those considerations are no longer explicitly in the regulation. However, it does seem clear from comments and some other case analysis that an immigration judge can still consider whether there are overly restrictive conditions that interfere with the person's inability to enjoy rights or privileges, including a pathway to naturalization within that third country, or if there are no significant ties, or if it's simply an incidental stay, incidental pass-through of that third country. So where an individual has been ordered removed, but the removal order cannot be executed due to statelessness, they will, in general, almost hard and fast rule, be placed under an order of supervision. And that is actually directed by the INA section 241A3. It says that you must be placed under order of supervision. This can be a very onerous and demoralizing status for an individual to have. You get a work permit, but it's almost always just for 1 year at a time. The person needs to go in for regular check-ins. Sometimes it's only once a year, but sometimes it's a lot more frequently. And where somebody has no citizenship, where they have a final order of removal, this could be for the rest of their lives. They can't go anywhere, they can't self-deport, they're stuck here, and there's no way for them to move forward or establish any kind of legal status in the US. So they're just on order of supervision for forever. Important to point out that it is unconstitutional to hold someone in detention indefinitely. So if you do have a client who is stateless and languishing in detention because they're trying to deport him or her, but there's no country that will take them, you can file a habeas corpus petition, and that was established by the Supreme Court in 2001. Which says that if the government is detaining an immigrant for a period of longer than 6 months, then they have to show cause as to why they are keeping that person for longer, or that removal is possible in the foreseeable future. Otherwise, they have to go on order of supervision. Order of supervision, keep in mind, you know, sometimes our victories are small with folks who have limited options. So you can make this person's life maybe a little bit easier by asking for certain de-escalation requests for their orders of supervision, right? If they've got an ankle monitor, ask them to remove the ankle monitor. If they've got frequent check-ins, maybe ask for it to be over the phone or less frequent. And we've actually had some success at United Stateless recently with both of those options. So before other immigration authorities, it's important to consider that there are some specific obstacles for stateless individuals. So certain immigration options are simply unavailable to stateless people. For example, consular processing. There's no consulate, well, there's no country where a consulate would be. They don't have the ability to travel, they don't have the ability to re-enter. It's not an option. Also, you know, what we see a lot is people who have been living without any kind of identity documents for their entire lives, sometimes falsify documents in order to, you know, engage with the basic necessities of life. So fraudulent documents, and also, you know, people who are pushed to the edges of society. We see a lot of collateral consequences of criminal convictions that can be devastating in immigration laws. I'm sure we all know. Also, what we see is sometimes very young people brought to the United States as children grow up with a false assumption that they are a US citizen, and then will falsely claim to be US citizens, and those exceptions of false claims to US citizenship are extremely narrow. Only if both of your parents are United States citizens, if you lived in the US before you were 16 and you reasonably believed that you were a citizen at the time. There are a few statuses that forgive false claims to citizenship, asylum, SIJS, but there are some, there was actually a recent example of a young veteran named Fidel Tencano, who was born to diplomats in New York, I believe. And because children of diplomats are not considered US citizens, even if born on US soil, because they're not considered subject to US law, they do not get birthright citizenship like other people born in the United States do. So that individual was believed he was a US citizen, given a US passport, you know, claimed to be a US citizen multiple times, and that caused him quite a bit of difficulty in his immigration case. However, I believe that was able to rectify and had a happy ending. So I'm happy about that. Also, just a couple other things to consider. Sometimes people don't have the ability to establish identity, and that can obviously make it very difficult to access even the most basic of immigration options. No permanent address. Obviously, you know, the immigration courts and USCIS deal exclusively in mail, pretty much. So if you don't have a place to receive mail, that can be a huge problem. Also consider that stateless people will always be ineligible for post-conclusion voluntary departure because they do not have the ability to comply with a voluntary departure order. So that's just off the table. And also that just like practitioners and even stateless people themselves, every level of U.S. government is largely unaware of statelessness as an issue, and it can be very difficult to move forward. So I want to talk for a second about some discretionary relief that may be available to stateless individuals. So David is going to talk about this a little bit later in the program, but consider parole in place for a stateless individual who needs to have been admitted or can't consular process, for example. Even though parole in place is usually applied to military veterans, active military and their family, the statute does not limit parole in place. In fact, doesn't say anything about military families or veterans. It says that it can be provided, it can be approved on a case-by-case basis for urgent humanitarian reasons or significant public benefit. So I'll let David explain more about that, but it is a really exciting new promise. When you need to apply for any type of waiver, I would urge you to consider including statelessness as a positive factor, humanitarian factor, and also evidence of persecution in the country of origin or the country that they may have to return to. Especially as a positive factor, I want to point out that in the 2023 omnibus appropriations law, Congress directed the Department of Homeland Security to consider whether statelessness should be a positive factor in applications for discretionary immigration benefits, waivers, or exercises of prosecutorial discretion for humanitarian reasons or in the public interest. Really important language. We're still waiting on a briefing from DHS as directed by the omnibus bill on this specifically, but also consider the director of the Department of Homeland Security, the Secretary Mayorkas, committed to addressing statelessness, defining statelessness, and we are still waiting for him to make good on that promise. And I think it's important to point out, both in waivers, prosecutorial discretion, or other types of discretionary relief, when you do have a stateless client, that promises have been made. The Department of Homeland Security acknowledges that this is a vulnerable population, and that it, is a humanitarian issue. And I think that can, it's important, and I think it can assist in getting you what you're asking for. I just also want to point out that it's important to keep in mind sensitivity in representation, as always, right? It's when we have immigrant clients, it can be a very daunting and difficult experience to go through the immigration system. So I'd like to pass it over to Karina, and she can explain a little bit more about what we mean.
Thank you so much, Samantha. I, just to bring in my personal narrative to this space, to paint a picture of the experiences that we're seeing, the systemic issues, is that the top issue that we're seeing, stateless people often don't know that they're stateless, right? This is a issue that I've never even heard of. Yeah, sure, I've seen Tom Hanks in The Terminal, but that's a movie. And I didn't realize that this is an issue that's going on in real time. This historical precedent to why this is an issue and solutions, but I didn't realize that this affected more than just myself or my family. I have my family and I have had years and years of representation, And then when I married my US citizen husband, we also went through 8 different lawyers, and none could tell us what we are or give us an idea of how to help us. And I understand that when clients come and seeking for help, oftentimes the answer is sorry, I just can't. But it's really hard to hear that your issue is just unsolvable. There's nothing you can do. And I think it's, as an organization that is led by those directly impacted and taking our experiences and how we are building our referral capacity and in-house representation, it is really important for us to use do due diligence to our members and our clients that are coming to our space, that we want to empower them and tell them, it is hard to hear when someone is first realizing that they're stateless, that they won't be able to reunite with their families, that they are unable to get a job, that they're completely left alone. And it's important that we're honest. This is happening. This is what you are. But we are a community. We have community space once a month, and I encourage you to refer your clients who are interested in joining our space, because oftentimes we're using our momentum and empowerment to make the changes that we desperately need in our lives and in each other's lives. I think managing expectations is key. Sorry, there's not a solution right now, but let's try. Let's work towards it. The hopelessness and mental toll is very real. I've witnessed it in my parents. I'm witnessing in some of the older members in our community versus the younger members that are, younger and maybe different view on life. But this toll kind of taxes on you, especially when you have been separated from your family, even after burial. It adds up. You're limited in how you can move around this country, and you feel really worthless. We really encourage you to contact us for any support that we can provide. Educating attorneys and academic institutions is a key priority for our organization, from personal experience, but also because, if this is happening in real time, we're seeing the rise of climate change and what that's doing in Pacific Islands. We're seeing what's happened in the US rollout from Afghanistan. We're seeing it in the Tigray region. We're seeing it in the invasion of Ukraine. Like, this is happening in real time. And unfortunately, without proper due diligence, a little mistake can lead a decade of someone not, exhausting all options or becoming ineligible for options. I also want to point out that the recent denationalization of Nicaraguans is a really important part, and it's part of this, point of it's happening in real time. And it's important that as attorneys that I recommend, and we highly recommend, to screen for statelessness and consider asking questions around someone's nationality from where they were born, and including that in any opportunity to show U.S. immigration authorities that this person is vulnerable. Samantha, over to you.
Oh, that's back to you, Karina.
The history of the Stateless Protection Act and how it came together. Fortunately, statelessness had a section in the Refugee Protection Act that was introduced over 10 years ago. And we took it upon ourselves to look at that text and expand on it now that we have a concrete number, an estimate of how many, 218,000, that's a CMS report that came out in 2020. And also importantly to, we're as an organization that works with directly impacted people and represents them while we advocate, we also saw a diversity of stories and how people become statelessness, and saw these areas in existing law that could be fixed to alleviate. These are based on those international frameworks that we pointed out earlier. And what we're doing is creating a status of statelessness in the US, implementing the international definition of statelessness, and also regularizing the status within existing immigration law. We want to see an opportunity for every stateless person in the United States to be screened for nationality, to determine that they are stateless, or stateless status determination, and to be put on a path to protective status, with the opportunity to adjust to naturalized, officially ending someone's statelessness when they become a US citizen. We want this to also extend to US citizens living abroad that are having children abroad, because those are some of the cases that we're also seeing. Countries that don't have birthright citizenship oftentimes do not give nationality to children born in their country, right? And we want to strengthen the Department of State's role in ensuring that parents have access to their facilities and resources to ensure that their child is protected and given that nationality. Anything you want to add to this, Samantha? I kind of breezed through it because I know there's a lot on this. And again, everyone's getting a copy of these slides.
Yes, I mean, I think you covered it. It is, yeah, we'll also pass out the language and announcement for the Stateless Protection Act, which I think gives a good summary. But it's you know, the new promise that we really do desperately need, because as we just covered, the options for stateless individuals can be extremely limited in immigration law.
Next week, April 26th, Wednesday, we are hosting a film screening at Aiken's Capitol Hill office, specifically inviting members of Congress and staff to join, to learn about the issue of statelessness through the personal narratives of some of our members. It's an 11-minute film that isn't publicly released yet, but we're having this private premiere to show. So if you have the capacity to help a little bit in calling your legislative representative or congressperson and to encourage them to attend. We are in, you know, we know that the biggest hurdle in all of our work that we have is educating. Most people have never heard of this issue. It is unknown, is misunderstood and underreported, especially in a country where we have birthright citizenship, which is great. But we want to identify that this is an issue. It's relatively affects comparably a small amount of people that really have nowhere to go. Please feel free to scan that QR code. If you have any questions, please feel free to contact us. And, you know, the Department of Homeland Security's commitment in 2021 was a big first step of recognizing, finally, the U.S. immigration authorities, or, you know, addresses or recognizes this is a problem. And their commitment is around adopting the definition of statelessness and enhancing protections for stateless people in the U.S. And we are really encouraged on the April 2021 to 2022 PBS NewsHour release and segment where Secretary Mayorkas is quoted, "I will tell you that we are going to move with the urgency that the vulnerabilities warrant." It's a positive sign for our community and members. And over to David.
Thank you, Karina and Samantha, and thanks to the ABA for inviting me to speak at this presentation. I'm David Benyon. I am the Executive Director of Free Migration Project, which is a small services and advocacy organization based in Philadelphia. I am a practicing immigration attorney, and I have the great pleasure and privilege of representing two of United Stateless's co-founders, Karina and Miljan, and we're in the slightly unusual situation of Karina also being a co-presenter, but also my client, and I'm her attorney. And with her permission, and also the other co-founding United Stateless member, we're going to briefly discuss their cases as case studies for somewhat novel or unusual ways to move forward in difficult immigration cases. So a little bit of the procedural history. We'll start out with Karina. Oh, I should just say too that our organization, we work at the intersection of law and community organizing to promote freedom of movement as a basic human right. and we call for a human right to migrate and the abolition of all deportation. Karina was born in the Soviet Republic of Ukraine. She and her entire family became stateless when the Soviet Union dissolved in the early 1990s. Her family, after going to Canada initially, came to the US without inspection in 1996 when Karina was a minor, applied for asylum, and then the family's application and all appeals were denied. Removal order issued just about 20 years ago now. Fast forward to DACA, and Karina was eligible, applied, and was granted DACA in 2013. But we, as attorneys, know well the limitations of DACA, not a path to citizenship. Despite Karina being married to a US citizen spouse. So brainstorming different scenarios, advanced parole wasn't really a viable option. We discussed, really brainstormed how Karina might go about traveling outside the US with DACA-based advanced parole and returning with inspection to be able to adjust under INA 245. But it just wasn't going to be feasible in our estimation, given her stateless status without any sort of travel document. So kind of stuck for a while, went ahead and got the I-130 approved, and with the idea of sort of adapting the parole in place strategy from the military family context, which turned out to be a successful strategy. First, we had to get the final removal order reopened with a prosecutorial discretion request to OPLA, which they agreed, and then submitted an I-131 and a parole in place request, generally tracking the requirements that have been set out for military parole in place. And then that was also approved, I'm forgetting the timeline, maybe 5 or 6 months ago. So far so good. That parole in place request and the PD request to join the motion to reopen, both well documented with lots of favorable equities. Statelessness was directly addressed as a factor as to why other relief was unavailable, and also as a positive discretionary humanitarian factor, which we believe helped play a role in these really fully discretionary types of relief. We engaged the ombudsman at one point after a lengthy delay in adjudication on the parole in place. And also important to note, throughout this, there was an existing, pre-existing channel of communication between Karina and her team and fairly high-level USCIS officials because of the ongoing advocacy that United Stateless has been engaged with. And now we have an adjustment application pending and are hopeful about that. So in the interest of time, I'll just move on to the next case study. Next slide, please, which is Miljan. Miljan was born in a country in East Africa, was stripped of his citizenship as a young man due to his ancestry and a conflict that arose then in his country of birth, came to the US because it was no longer safe for him there. He came in 2001. His asylum application was denied in removal, first at the asylum office, then immigration judge, then BIA, then appeals to federal court. 2 subsequent motions to reopen were also denied, plus appeals. And so then Miljan got involved with United Stateless, became a co-founding member, became involved with some of the advocacy that that organization has been doing with their network. And also, I should mention, both he and Karina both received statelessness determinations from the UNHCR, which was a very helpful piece of evidence in both of their cases. And so essentially, along with National Immigration Project of the National Lawyers Guild, and also collaborating closely with United Stateless itself, prepared another PD request for Million to OPLA again to join the motion to reopen. This also was granted. The BIA approved the joint motion, and the case is back on remand and removal proceedings after, again, about 20 years. And that's where we're at with Million's case for now. There's a lot more details for both cases that we just don't have time to get into. So, next slide, please. Trying to draw some lessons from these, in my experience, somewhat unusual outcomes, especially with regard to OPLA agreeing to PD and joining a motion to reopen for very old removal orders in asylum proceedings. In my experience with other clients, that's been hard to do. So what was the difference here? And it's a bit complex, but I think we can draw some lessons. Both applications were thoroughly documented. The legal remedies were clearly defined. Again, I mentioned the stateless status determination from the UNHCR played a role, I think, in both cases. Both cases were a community-supported collaborative effort. It wasn't just the lawyer and the client going it alone. This helped build an evidentiary record and helped engage the agencies, we believe, in ways that are not completely transparent to us, but we believe had an impact. Both the applicants are United Stateless co-founders active in advocacy with a public profile. I'll just make a mention of the sort of obvious confidentiality issues, both with sharing case details in this forum, but also more broadly. Both Karina and Million were featured on that PBS spot that ran about a year ago that Karina referenced, and have otherwise been open and public about their case situations. They've taken on the burden of public advocacy on behalf of themselves and the entire stateless community. There are risks to that, but also rewards, both for them and for the broader community. We, as client and attorney, discuss questions of confidentiality and public visibility together, not just once at the outset of representation, but consistently throughout the course of the representation. And this requires a lot of consistent communication, not just between the client and the attorney, but also between the attorney and other campaign partners. I mentioned that both applicants have been involved with advocacy for policy reforms that would benefit stateless people. Karina mentioned that Secretary Mayorkas personally committed to these types of protections in 2021, has failed to deliver. I love Karina's optimism and hopeful and positive approach. I'm more of a pessimistic person, and I'm like, come on, Mayorkas, DHS, what's going on? But putting them on the back foot, it becomes a moral issue. They have promised things they have not delivered. Can they at least deliver some of the types of reforms in individual cases that they promised? And in these two cases, they have. Next slide, please. Just really briefly, because I know we want to leave a bit of time for Q&A. These cases adapted a more general model that we use sometimes and other organizations have used of community-supported legal defense. It's important to have a strategy. Create a case campaign plan. We learned this from community organizers. Lawyers tend to do this already in some respects, but we can learn a lot from community partners with power mapping. Identify your clear objectives. What do you need from a case? What's your near-term and long-term goals? Based on that, identify who can give you what you want. Is it OPLA? Is it USCIS? Is it somebody else? Do a power mapping. Who do you need to get to those ultimate targets? Formulate your strategy, identify tactics, and we're off to the races. An important element of this has been community support, which, as I mentioned, can help with the legal case on its own merits. You get a much better evidentiary record when you're working with community partners. And And, you can engage community support without having a public campaign or making any case details public or engaging elected officials. It can be sort of an ad hoc advantage in some cases. In other cases, the strategy is with the client and all community partners and attorneys agreement to go public. It's not for every case, it is for some. And then based on those other elements of a legal strategy, a community strategy, publicity, you can in some cases engage decision makers in a much more robust way than getting this normal sort of constituent services brush off, so that they actually feel engaged in the case and try to intervene with the agencies that we're targeting. Immigration law is arbitrary, opaque, and morally illegitimate. These factors normally work against our clients, but they can also be an advantage in that legal determinations in immigration law can be subject to influence and intervention by the public and by elected officials. And that's kind of what we're going for in some of these cases. And I'll stop there.
Thank you so much, David. Thank you all for joining us. Just to recap, because we're really running short on time, remember to screen for statelessness, to bring it up at the very beginning of proceedings. Remember to assert it as an asylum basis for asylum, advocate for big and small improvements, get creative, reach out to USL for more support, think about community engagement, and support our work. We will also be distributing a sort of a resource guide and other resources, including how to get in touch with us, how to reach out for mentorship or support on a case, to send us a case. We do some direct representation in certain cases, so we can send that all to you. So I know there were some questions in the chat. I just want to address one really quickly from Christopher Strawn. Thank you so much for pointing out that the 2020 rule change that I mentioned in the firm resettlement issue was enjoined. So the major changes to consider there are that 1 year stay is not the presumption, and neither would be eligible to receive permanent residence. In fact, it's whether it was offered. That's what the standard was previously. So thank you so much for pointing that out. I see one other question. Maybe I think I know the answer, but maybe Karina or David want to answer. Have there been any updates to that announcement from December 2021, Mayorkas's and the Biden administration's commitment that they would introduce a definition on statelessness? Any positive changes that we've seen from the administration?
Not yet. I know that they're working on it. I am more positive than David. Good old Philly cynicism, but we are in constant communication, which is a really good first step. And I know that this is an enormous issue to resolve. I know it's hard to identify or how to, for authorities to see how statelessness appears and where exactly this fits under, short of law reform. But we're really hopeful. And I'm hopeful that the first two cases that we brought up, which is my case and, colleagues, Million's case, is a first big step in recognition. I also want to point out that David and my husband and I have known each other for 10 years. And I'm really grateful for this relationship. It was a form of legal empowerment for us, but I find myself being really open about my story because it has to mean something. And also because I know it can help. There's other people that are in this situation, and the more knowledge sharing that we can do, I think the more beneficial it is.
Yeah, great. I'm gonna quickly answer a couple other questions from the chat here. Someone asks, can a stateless spouse qualify as asylum derivative to her husband's asylum? Yes. Yes, absolutely. There's no restrictions there. The obstacles, of course, would be if the person has no identity documents, that could be a bit of a challenge, and you'll have to use sort of less direct documents to prove that person's identity in order for them to even make the application. And here's a really good question. Is there a legal process that confirms when someone is stateless? And the answer to that is, under the US framework, no, not explicitly. First of all, as we mentioned, there is no definition, there's no federal definition for statelessness in the United States. So what you can do is basically, through a combination of documents and legal analysis of the applicable country's nationality laws, make the argument, and show through basically a series of documents rather than a specific process or a single document that a person is indeed stateless. Sometimes it's easier than others. Sometimes, a person has a claim to only one country, and that country will provide a letter saying, we do not recognize you as a citizen, and that can be sufficient. But sometimes it's a lot more complicated, where the person has no documents whatsoever. No country is willing, or is maybe just ignoring your requests to issue a passport. And it can be a more complicated analysis at that point. So that's something that we are certainly pushing for making it easier to establish statelessness, because that is, of course, one of the threshold questions here. I think we're over time already, Stephanie.
We are over time, and thank you. I was just typing into the Q&A here to let someone know that we will be circulating the recording from this presentation, as well as the wonderful PowerPoint slides. And we'll also circulate the recording for part 1 from this presentation, and those slides as well, so everyone has all of the information. It's been a great Q&A and a wonderful, wonderful panel. Thank you so much to Samantha, David, and Karina for sharing all of your information with us. This has been a really valuable presentation for the whole audience. So we can't thank you enough. And thanks to the audience for being part of it. And we'll send out the materials. It might take a day or two before we get them out, but we will be sending those to everyone. So thank you all so much for joining us today. Take care, everyone.
Thank you.
Thank you.